Hello, everyone, and welcome to Uncivil Law. We recently covered a Sixth Circuit Court of Appeals case dealing with the right of education, and so I thought it might be a fun idea to cover a more foundational case in this area. The right of education, does it exist? So let's cover the question from the United States Supreme Court when they answered that question. This is San Antonio Independent School District versus Rodriguez. In this case, the state of Texas has a system of funding schools, which leads to unequal funding in different places because, like many states, if not all states, they use property taxes, at least in part, to fund schools, which means different places get funded at different amounts. So does that represent an equal protection problem? Are students being treated unequally based on where they live, based on protected reasons or otherwise? So let us read this case and find out about the fundamental right to education. Let's get started with this. This lawsuit attacking the Texas system of financing public education was initiated by Mexican-American parents whose children attended elementary and secondary schools, which, for those of you who are not from the United States, elementary school is typically, although not always, K through 5. And secondary schools are typically grades 6 through 12. So that's typically how that's split. And then, of course, secondary schools are usually split into middle schools and high schools, but they're all considered secondary. Anyways, so these children attend elementary and secondary, which in their collective are K through 12, in the Edgewood Independent School District, an urban school district in San Antonio. These students brought a class action on behalf of school children throughout the state who are members of minority groups or who are poor and reside in school districts having a low property tax base. A 3-judge district court panel was impaneled in 1971, and the district court, which is 3-judge, rendered its judgment in a per curiam opinion, holding that the Texas finance system unconstitutional under the Equal Protection Clause. For these reasons stated in this opinion, we reverse. So not that it particularly matters, but because this was a 3-district court opinion, that meant that the Supreme Court couldn't choose not to hear this case, because the Supreme Court is the appeal court for a 3-judge court. So I'm not 100% sure why this was a 3-judge court. I'd have to go look up the relevant statute. But for some reason, this is a 3-judge court, which means that the United States Supreme Court has to hear this case. They love it when they have to hear cases. So anyways, the United States Supreme Court, now being the Court of Appeals, has to decide whether or not the district court was correct. So let's figure that out. Yeah, 1971 primary was 1 through 12. It depends where you are. I don't think there's a universal rule. Even when I went to primary school in Pennsylvania, it was 1 through 6. But then when I moved to South Carolina, it was 1 through 5. So I think it just depends where you are. It just depends where you are. I don't think there's a universal rule. So some places I think are still 1 through 6 and some 1 through 5. And then middle school sometimes is 6 through 9 and sometimes it's 6 through 8 and blah, blah, blah. It doesn't matter. Recognizing the need for increased state funding to help offset disparity in local spending and to meet Texas's changing educational requirements, the state legislature in the late 1940s undertook a thorough evaluation of public education with an eye towards reform. In 1947, a 18-member committee composed of educators and legislators was appointed to explore alternative systems in other states and to propose a funding scheme that would guarantee a minimum or basic educational offering to each child and would help to overcome inter-district disparities in taxable resources. The committee's effort led to the passage of several laws establishing a Texas minimum foundation school program. Today, this program accounts for approximately half of the total expenditure in Texas. So, at least at this point in Texas law, again, this is in the 1970s, but at least at this point in Texas law, they moved to a system that was essentially half funded by the state and half funded by localities, which is not completely unusual. Usually there's some hybrid in spending. Some states are more local than others, but it's usually a combination. So at this point in history, it's roughly half and half. The program calls for state and local contributions to a fund earmarked specifically for teacher salaries, operating expenses, and transportation costs. The state, supplying funds from its general revenue, finances approximately 80% of this particular program, and school districts are responsible for 20% of its particular program. Today, and again, this is 1970, so by today we mean 1970s, but in 1970s, every school district imposes a property tax from which it derived locally expendable funds in excess of the amount necessary to satisfy its local fund assignment under the foundational program. So every locality is charging property taxes, which is typical. In the years since the program went into effect in 1949, expenditures of education from state as well as local sources have increased steadily, so education is getting more expensive. Between 1949 and 1967, expenditures increased approximately 500%, so it went up by a factor of 5. That's a lot. In the last decade alone, again, this is 1970s language, so factor that in. So in the last decade alone, basically in the 1960s, the total budget rose from $750 million to $2.1 billion. That's $1970. So, multiply that by a little bit more to get an idea of what we're talking about. These school districts in which these people who are suing reside, the Edgewood Independent School District, has been compared throughout this legislation with Alamo Heights Independent School District. So there are two districts being compared, which is not an entirely unreasonable thing to do. So Edgewood is being compared with Alamo. All right. Don't forget the Alamo, I guess, goes to the U.S. Supreme Court as well. This comparison between the least and most affluent districts in San Antonio, so one is the poorest district, one is the richest district, so that is the greatest disparity. Fair. So the comparison between these tale of two cities, serves to illustrate the manner in which this dual system of finance operates and to indicate the extent to which substantial disparities exist despite the state's impressive programs in recent years. The Edgewood District, which is the poorest, is one of 7 public school districts in the metropolitan area. Approximately 22,000 students are enrolled in its 25 elementary and secondary schools. That asterisk 12, by the way, is a page number, not a number, so that's why I read it that way. The page, that asterisk 12 is the page number, so it's not part of the opinion. So there are 25 elementary and secondary school educations. Ignore the 12. The district is situated in the district that we're talking about is situated in the core city area of San Antonio. So the poorest district is in the middle of San Antonio, in a residential neighborhood that has little commercial or residential property. The residents are predominantly Mexican-American of descent. Approximately 90% of the student population is Mexican-American and 6% is Black. Again, 1970s language for you here. The average assessed property value per pupil, again, $1970. The average assessed property value is $5,960, the lowest in the metropolitan area, and the median family income of $4,686 is also the lowest. At an equalized tax rate of $1.05 per $100 of property, the highest in the metropolitan area, so they're the highest tax rate, the district contributed $26 to the education for each child in the 1967-1968 school year above its assessment for the minimum foundation program. The foundation program contributed another $222 per pupil for state local for a total of $248. Federal funds amount to $108 for a total of $356 per pupil. So in this poor school district, the way I'm reading this and the way I'm understanding this, and I might be reading it wrong, but I think I'm reading this correctly. The way I'm reading this is that when you add up all the monies that are collected, we are funding the students at $356 more than the minimum that was required by the state. So we are $356 per pupil, again, $1970. We are $356 per student above the bare minimum, I think is what that says. But that's in the poorest school district. So let's compare that to the not poorest school district. How does it compare across the road? The Alamo Heights is the most affluent school district in San Antonio. Its 6 schools, housing approximately 5,000 students, are situated in a residential community quite unlike Edgewood. The student population is predominantly, I'm guessing, white, having only 18% Mexican American and less than 1% Black. The assessed property value per pupil exceeds $49,000, which is quite a lot more than we were talking about, like a factor of 10 times more. So the property value is about 10 times more here. And the median family income is about $8,000. In 1967-1968, the local tax rate of 85 cents per $100, so we had a lower tax rate, but it yielded $333 per pupil because there was more money to tax, over and above its contribution. Coupled with $225 from the program and other funds, that raised to $594. So in the poorest school district, as I'm reading this, in the poorest school district in San Antonio, we were $356 above minimum. In Alamo, we were $594 above minimum. So that's roughly 50% more. And again, these are $1974, so you'd have to adjust. But I think the greatest takeaway here is it's 50% more. So in the richest school district, we're funding 50% more above minimum than in the poorest school district. So presumably on the basis that money means access to things, that is less access, which is not necessarily desirable. So Is that a constitutional violation is the next question. Despite the recent increases, substantial intra-district disparities, that is, disparities between the districts within the same city, these disparities in school expenditures found by the district court to prevail in San Antonio and varying degrees throughout the state still exist. So this is not just a San Antonio problem, not that you'd expect it to be. This is a problem statewide, and for that matter, nationwide. And it's these disparities, largely attributable to the differences in the amount of money collected through local taxation, that led the district court to conclude the Texas dual system of financing violated the Equal Protection Clause. The district court held the Texas system discriminates on the basis of wealth in a manner in which education is provided for its people. So the three-judge district court said this dual system is a violation because you have a disparity, and you are creating a disparity on the basis of wealth. And that is not a permitted reason. You can't treat people just because they have more money differently than people that they have less money. Equal protection under law. Rich doesn't entitle you to more government. So there's a disparity, or at least that's what the district court said. So now the United States Supreme Court, which again couldn't avoid this case because it is the Court of Appeals, because that's the way the law is written. The United States Supreme Court, as the Court of Appeals, has to figure out whether or not that's true. Is this a disparity? Is it a disparity that's protected by law? Is there a violation here the United States Supreme Court should or do something about? Let's read on. We, the United States Supreme Court, must decide whether the Texas system of financing operates to the disadvantage of some suspect class or impinges on fundamental rights explicitly or implicitly protected by the Constitution. So are we discriminating on the basis of a suspect class, which would typically be like race, would be the most obvious example, or national origin potentially? So are we discriminating that, or are we impinging on a fundamental right, in which case that's also bad? So if so, the judgment of the district court should be affirmed. If not, the Texas scheme must be examined to determine whether it rationally furthers some legitimate interest and does not constitute an invidious discrimination violation of equal protection. So if it discriminates on the basis of protected class, race, age, sex, national origin, that kind of thing, then it's invalid. If it impinges a fundamental right, it's invalid. Otherwise, it might be valid if it is at least rational, if it's rationally related to a legitimate interest. So rational basis scrutiny. So if it impinges on one of these fundamental rights, strict scrutiny. If it doesn't, then rational basis. So we have to figure out which of those two things so we can get to the right level of review. The wealth discrimination discovered by the district court in this case, and by several other courts that have recently struck down similar school financing laws in other states, is quite unlike any other form of wealth discrimination that we have reviewed in this course. So we have seen wealth discrimination cases before, but this is unlike those cases. The precedent, the prior cases that we've discussed of this court, provide a proper starting point. The individuals or groups of individuals who constitute the class discriminated against in our prior cases shared two distinguishing characteristics. Because of the impunity, so because of their lack of money, they were completely unable to pay for some desired benefit, so they were excluded out because of money. As a consequence, they sustained an absolute deprivation of a meaningful opportunity. So in the prior cases the U.S. Supreme Court saw, the lack of money was a complete barrier. They couldn't get anywhere that they wanted to be. So, where that is a problem, that is reviewable, but that isn't the situation here. These people aren't being squeezed out. They're still getting education. Maybe it's not as great an education, but it's different in that they're getting something rather than nothing, which was the cases in the other situations the Supreme Court had reviewed before. The prior cases do not touch on the question of whether equal protection is denied to persons with relatively less money, on whom designated fines pose heavier burdens. The Supreme Court has not held that fines must be structured to reflect each person's ability to pay in order to avoid disproportionate burdens. So if we were talking about a fine, you don't have to scale those. So that would be another example where this doesn't apply. Sentencing judges may and often do consider a defendant's ability to pay, but such circumstances, they're guided by judicial discretion rather than mandate. So again, when you're talking about a fine, you might have to set a limit and you don't necessarily have to scale it. So maybe this is of that kind. Only the people suing's first possible basis for describing the class disadvantaged by Texas school financial system, discrimination against the class of definitely poor persons, might arguably meet the criteria established in prior cases. Even a cursory examination, however, demonstrates that neither of the two distinguishing characteristics of wealth classification can be found here. First, in support of the charge that the system discriminates against the poor, the people suing have made no effort to demonstrate that it operates to a peculiar disadvantage of any class fairly definable as indigent, or composed of persons whose income are beneath any designated poverty level. A recent and exhaustive study of school districts in Connecticut concluded that it is clearly incorrect to contend that poor people live in poor districts. Thus, the major factual assumption of the different case in that situation, that the educational financing system discriminates against the poor as such, is simply false in Connecticut. Defining poor families as those below the poverty level, the Connecticut study found, not surprisingly, that poor were clustered in commercial and industrial areas, and those areas are able to provide property tax income for school districts. So, again, here in these wealth disparity cases, the wealth disparity cases are, again, you can't target people because they're poor. You can't squeeze people out because they're poor, but you can tailor things to the amount of money that they have. So the wealth category is not a protected class. That being the case, though, the government acts arbitrarily and capriciously if it tries to squeeze the poor completely out of participation, because that doesn't make sense. That's the sort of thing that makes a poll tax illegal. It's the kind of thing that makes when you are filing paperwork to engage in a parade, it makes the fee only so large as it needs to be to file the paperwork, not to provide security and things like that. So when government is setting fees, they can't set it at a high rate to squeeze people out of the system. They can set it to make themselves whole. They can set it to take care of the administrative burdens, but they can't squeeze the poor out of the system. And in the prior cases that the Supreme Court had considered, those examples, the poor have been squeezed completely out. They were completely unable to participate. And here, that's not the same situation. So, and also they're pointing out that even it's a little bit unequal. It's not quite the same situation because here, unlike those cases, they're not discriminating against the poor as such. In those cases, they were, for example, setting fees so high that no poor person could pay, right? So that the regulation was tied directly to wealth. But here it's not tied directly to wealth because here it's being based on school district. And as this Connecticut study was pointing out, you can't just say that poor people live in poor districts. They might to some greater degree, but the poor are not being discriminated as such. They're not being discriminated against their poor. They're being discriminated against geography, which is a little bit different. So you're not saying, oh, you must pay $500 to file this paperwork, which inherently discriminates against the poor because the poor don't have as much money. You're basing it on geography. And so you're not even targeting the poor. There's no... The situation doesn't work because A, you're not targeting them, and B, they're able to participate. So the prior factual situations in the prior cases don't work for that analysis. Neither the people suing nor the district court address the fact that unlike any of our precedent, the lack of personnel resources has not occasioned an absolute deprivation of desired benefit. The argument here is not that children in districts having relatively low accessible property are receiving no education, rather it's that they're receiving a poorer quality of education than those in accessible wealth. So again, the precedent is a little bit off point. They are able to receive a benefit, and they are able to receive apparently what Texas deems to be a minimum benefit, because if I read the numbers correctly, they're receiving more than the bare minimum, just not as much as their comparative colleagues. So they're not even out what Texas deems to be a minimum education by its own rules. For these reasons, the absence of any evidence that the financing system discriminates against the poor as such, or that it results in an absolute deprivation of education, the disadvantaged class is not susceptible of identification in traditional terms. So there is no class that can seek remedy in this way. Okay, so having decided that fails initially, the United States Supreme Court is going to take a little bit more look at this and try to decide whether, despite the fact that it doesn't meet the precedent, whether or not this is a different situation. I mean, it is different in some way. So the precedent may or may not guide this. It doesn't fit into the cases we've decided before. But of course, that doesn't unto itself mean that we shouldn't do something new. So the Supreme Court is now going to consider whether or not there's evidence that would lead the Supreme Court to establish a new rule. So let's consider the evidence and see whether or not a different kind of rule should establish for this kind of case, because it's different than the kind of cases the Supreme Court's seen before. The district court, relying in major part upon the affidavits and apparently accepting the substance of the people suing theory, the district court noted a positive correlation between the wealth of school districts, measured in terms of assessable property per pupil, and their level of per pupil expenditures. So richer districts spent more money. Second, the court found a similar correlation between district wealth and personal wealth, measured in terms of median family income. So the district is wealthier if the people in it are wealthier, which is kind of what you'd expect. The Supreme Court says, if in fact these correlations could be sustained, it might be argued expenditures on education, equated by appellees to the quality of education, which again may or may not be the same thing, are dependent on personal wealth, and perhaps that might be a problem. The Supreme Court just noticed that the district court, in reaching its conclusions, relied in heavy part on an affidavit. And so now the Supreme Court is going to talk about the affidavit and what it does or does not show that would be relevant to the legal findings here. The affidavit the district court considered, that was written by Professor Burke, is a survey of approximately 10% of school districts in Texas, which isn't bad. His findings, previously set out, show that only the wealthiest few districts in the sample have the highest median family incomes and spend the most on education, which you'd expect, and that several poorest districts have the lowest family incomes and devote the least amount of money to education, which you'd also expect. For the remainders of the districts, 96 districts composing almost 90% of the sample, however, the correlation is inverted. So for 10% of school districts, it's what you'd expect. However, for 90% of school districts, it's not what you'd expect. So for 90% of school districts, the districts that spend next to the most money on education are populated by families having next to the lowest median family income, while districts spending the least have the highest median income. So in 10% of the cases, the correlation is what you'd expect. But in 90% of cases, it went the other way. Cases that are richer spend less, and places that are poorer spent more. So it's evident that even the conceptual questions were answered favorably by the people we're suing. No factual basis exists upon which the comparative claim wealth discrimination. So yeah, when you actually look at the actual numbers, the correlation didn't even bear itself out. So yes, in 10% of the cases, the richer districts spent more money and the poorer cases spent more money. But perhaps surprisingly, according to this affidavit, again, which the district court relied on, in 90% of the cases, it didn't work out that way. Richer places spent less money and poorer places spent more money. So yeah, it didn't even hold that their factual underpinning was correct. So maybe if it could have been shown, but the affidavits didn't even show what they were purporting it to show. So that doesn't work at all. However described, it is clear that this suit asks this court to extend its most exacting scrutiny, which is other language for strict scrutiny, by trying to make this protected class. So you're trying to make this a strict scrutiny issue. You're trying to extend its most exacting scrutiny to review a system of discrimination against a large, diverse, and amorphous class, which is how that works, unified only by a common factor of residents in district that happen to have less wealth than other districts. So you're not discriminating against a protected class. That's not how we typically do this. The system of alleged discrimination and the class it defines have none of the traditional indicia of being suspect. The class is not saddled with the disabilities of being a suspect class, or subject to a historical, purposeful, unequal treatment, or regulated to such a position of political powerlessness as to command extraordinary protection from the majoritarian political process. Yeah, not to put too fine a point on it, but half the people are, by definition, below average earnings, average wages, average income, average wealth. So yeah, the poor are not politically disadvantaged because half the people are poor compared to the other half, definitionally. So, they are not, they have equal political power to their more richer parts because they have equal voting power. So they can participate in the system to the same degree as anyone else. So they are not in a disadvantaged class. They are not, they've not been prevented from being part of the citizenry. So it's not in the same category as, what we did to people of certain races, where they were most deliberately kept outside of the system by law for vast periods of time. And so that may suspect, not what we were doing to the poor, no. We thus conclude the Texas system does not operate to the peculiar disadvantage of any suspect class. It has been argued that the state's system impermissibly interferes with the exercise of a fundamental right, and accordingly prior decisions require application of strict scrutiny. So, having dealt with the issue of whether it's a suspect class, we now have to deal with whether or not it impedes a fundamental right. So as this question, whether or not education is a fundamental right, in the sense of other rights protected by the Constitution, which has consumed the attention of courts and commentators. So, yeah, at this point in history, the United States Supreme Court hadn't reached this question. Other courts had obviously reached the question. It had been considered in the legal journals and legal articles whether education is a fundamental right. But, this issue as whether or not education is a fundamental right, the Supreme Court has never spoken about. So now it has to decide based on the commentary whether it's a fundamental right. So having decided that it's not being assessed by class, is it impeding a fundamental right? So now we have to consider that. In Brown versus Board of Education, a unanimous Supreme Court recognized that education is perhaps the most important function of state and local government. Nothing in this court's holding today in any way detracts from our historic dedication to public education. We are in complete agreement with the conclusion of the three-judge panel below that the grave significance of education, both to individual and society, cannot be doubted. But the importance of service performed by the state does not determine whether it must be regarded as fundamental for the purpose of examination under equal protection. So whether something is important and whether it's even in some sense necessary is not to say whether it's constitutionally required. Those are completely different questions. So education being important, being essential to society maybe, that's one thing, but does the Constitution guarantee it? That's the question the Supreme Court has to decide right now. The lesson of these cases in addressing this question, whether it's fundamental, now before the court is plain. We are now confronted with the question. We actually have to decide it. It is not the province of this court to create a substantive constitutional right in the name of guaranteeing equal protection of law. We don't create new rights out of nowhere. Thus, the key to discovering whether education is fundamental is not to be found in comparisons of its relative social significance or of education as opposed to other things, such as housing. Nor is it to be found by weighing whether education is important as, say, the right to travel, which sovereign citizens love very much. Rather, the answer lies in assessing whether the right to education explicitly or implicitly is guaranteed by the Constitution. So this is not a comparative analysis. Is education more or less important than, say, the right to travel? Is it more or less important than, insert your constitutional right of choice? Is it more or less important than the right to speech? I don't know. Is it more or less important than the right to be secure in your property? The Supreme Court says this is the wrong question. The question isn't whether it's important compared to any other interest or even any other constitutional right. Because, maybe you can make a credible case the right to education is more important than the right to travel, which doesn't protect a particular means of travel, incidentally, sovereign citizens. Yes, you have the right to travel. It doesn't mean you get to choose your means. But yes, you have a right to travel, state to state, no papers, as they say. But anyways, even if you conclude that education is more important, that's not the question. The question is, does the Constitution protect it? More or less important is not the issue. Is it constitutionally guaranteed? That's the importance. That's the question. The Supreme Court has long afforded zealous protection against unjustified government interference with fundamental rights, such as the individual's right to speak and the right to vote. Yet, we've never presumed as a court to possess either the ability or the authority to guarantee to citizens the most effective speech or the most informed choice. Yeah, you have a right to speak, but we're not guaranteeing your right to be informed, which is probably pretty good because there's a lot of uninformed people speaking, nor are we guaranteeing your right to speak in the most effective way. Everyone does not get a radio transmitter for free. These may be desirable goals of a system of freedom of expression and of a representative form of government. That's not to be doubted. These are indeed goals to be pursued by people whose thought and beliefs are freed from government interference. The government can't interfere with you, but these are not values to be pursued by implementation, by judicial intrusion into otherwise legitimate state activities. So yes, these are political issues, not judicial issues. The government has an obligation not to interfere with you. The Constitution protects negative rights. The Congress shall not abridge your freedom of speech. Does that require the Congress to give you freedom of speech? It does not. It requires the government to do absolutely nothing of any kind or variety that would any way facilitate your freedom of speech. They are specifically prohibited from doing stuff, but they are in no way obligated to do stuff. So the First Amendment gives you the freedom of speech. Does that mean that you have a right to be informed? No, not particularly. Does that mean that you have the right to have effective means of speech? No, not particularly. The government doesn't have to provide you anything. Maybe they should. Maybe they should. Maybe they should give everyone a free subscription to the local newspaper. I don't know. Maybe that's the thing the government should do. But that's a political question. Whether or not the government should do that is up to the citizens of it. So if your local government wants to give everyone a free subscription to the newspaper or whatever, then that might be okay. If the government wants to do stuff, yeah, that might be okay. But it's not for us as a court to figure out. Those are political issues, not jurisdictional issues, not judicial issues. So don't come to a court to ask us to give you stuff. Don't come to the court and ask us to give you stuff. Ask us to prevent the government from taking stuff from you. That will be fine. But yeah, no, this is not the kind of thing the government has to do. Furthermore, the logical limitations of the nexus theory are difficult to perceive. So, as always, the Supreme Court wants to know, what is the limiting principle? That's always a real good question. Anytime you're arguing anything before any court anywhere, it's always good to know, what is the limiting principle? Where does your principle stop? What are the principles on which it stops against? Now, in many areas, we have very good answers to these questions, like First Amendment. Where does the First Amendment stop? Well, we know some answers to that, like time, place, manner. We know some things that may not be First Amendment protected, such as defamation. We have limiting principles, right? You have a freedom of speech. Where does it stop? I'm so glad you asked. I have limiting principles to describe to you, and I can describe to you for several hours, which I'm not going to do right now. So here's the question to these people who are suing. Where is the limiting principle for you? Okay, you say you have a right to education. What is the limiting principle? How much education? Why education and not other things or other stuff? What is the limiting factor here? It's like, we can't find one. The courts don't like it when there's no limiting factor, man. They don't like to run off the edge. They are always concerned about what happens next. They really dislike an open void. It's like a black hole. It's going to subsume everything. The Supreme Court is very, very worried about the slippery slope, as well they should be. So they'd like to know where this ends. And if you don't have a good answer to that question, you're going to have a bad time. The Supreme Court asks, how, for instance, is education to be distinguished from other significant personal interests in basics of decent food and decent shelter? Yeah, that's a really good question. If you have a fundamental right to education, like, why don't you have a fundamental right to shelter or a fundamental right to food? Does the government have to give you food? Does the government have to give you housing? And if so, what kind of food and what kind of housing might be the next logical questions? What are the limiting principles here? These are good questions. Empirical examination might well buttress an assumption that ill-fed, ill-clothed, and ill-housed are among the most ineffective participants in the political process, and they deserve to have the benefits of the First Amendment. Yeah, so the Supreme Court is taking a flyer, and the Supreme Court is making assumptions, which I know some people on this channel hate for some reason. But the Supreme Court is making an assumption. The Supreme Court is saying, I bet if we did a sociological study, that we would find that, on average, those people who are ill-fed, ill-clothed, and ill-housed are less effective in political participation than those who are not. We are going to take a guess. We are going to guess that people who are particularly ill-clothed, ill-fed, and ill-housed are not particularly effective. So if the idea is that, everyone has a fundamental right to participate, then presumably we would have to feed people, clothe people, and house people at least to some minimum level. What that minimum level is, I don't know. But yeah, if the idea is that education provides you the ability to be more able to engage in being a citizen, if the idea is freedom of speech, for example, your freedom of speech interest or your freedom of assembly interest or even your freedom of press interest, if the idea is that that is informed by money in terms of education, then presumably it would apply to these other things. What is the limiting principle? You don't have a limiting principle. Does the government have to give you food, clothing, and shelter? To what degree? What are the limits? You don't seem to know. So it's like, yeah, if education is important, how about this other stuff? Is that also important? It's like, we can't find a limiting principle, so we're not going to say you have a fundamental right, which makes perfect sense to me. The Texas system of school financing is not unlike federal legislation involved in a different case in this regard. Every step leading to the establishment of the system in Texas that is utilized in 1970s, including the decision permitting localities to tax and expend on a local level, and creating and continuously expanding state aid, was implemented in an effort to extend public education and improve its quality. So all these things the state are doing are trying to improve it, trying to bring more money in. Your argument is it's not enough, but the state's trying to do stuff. Of course, every reform that benefits some more than others may be criticized for what it fails to accomplish. But we think it plain that, in substance, the thrust of the education system is affirmative and reformatory, and therefore should be scrutinized under judicial principles sensitive to the nature of efforts and the rights reserved to the states under the Constitution. In sum, to the extent that the Texas system of school financing results in unequal expenditures between children who happen to reside in different districts, we cannot say that these disparities are the product of a system that is so irrational as to be invidiously discriminatory. Texas has acknowledged some shortcomings and has persistently endeavored, not without some success, to ameliorate the differences in the level of expenditures without sacrificing the benefits of local participation. The Texas plan is not the result of a hurried, ill-conceived legislation. It is certainly not the product of purposeful discrimination against any group or class. On the contrary, it is rooted in decades of experience in Texas and elsewhere, and in major part is the product of responsible studies by qualified people. In giving substance to the presumption of validity to which the Texas system is entitled, it is important to remember that every stage of development is constituted a rough accommodation of interests to effort to arrive at a practical and workable solution. The constitutional standard under the Equal Protection Clause is where the challenged state action rationally furthers a legitimate state purpose or interest. We hold the Texas state plan abundantly satisfies this standard. Any practical considerations, of course, play no role in our adjudication of constitutional issues. We don't do practical, we do law, or we don't do very much of it. That's for a different branch of government to do. But the practical considerations serve to highlight the wisdom of traditional limitations on this court's function. So the practical factors help to show why the court can only do certain things. The consideration and initiation of fundamental reforms with respect to state taxation and education are matters reserved for the legislative process of various states. And we do not do violence to the values of federalism and separation of powers by staying our hand. So we aren't like doing a bad thing by not doing something. We are not, silence is not violence, says the Supreme Court. Silence is not violence. Just because we're not going to do something doesn't mean that we are doing violence to federalism. Different branches of government have power too. We hardly need to add that this court's action today is not to be viewed as placing its judicial imprimatur, which I always love that word, imprimatur. It's the seal of approval. It need not put its judicial seal of approval on the status quo. So we're not saying the status quo is necessarily the greatest thing ever. The need is apparent for reform in tax systems, which may have relied too long and too heavily on local property tax. Maybe local property tax isn't the greatest format. And certainly, innovative thinking as into public education, its method and funding is necessary to assure both a higher level of quality and greater uniformity of opportunity. These matters merit the continued attention of scholars who have already contributed much to these challenges. But the ultimate solutions must come from the lawmakers and from democratic pressures of those who elect them. So that is the end of the coverage of San Antonio Independent School District versus Rodriguez, which deals with whether or not there is a fundamental right to education. And we learned that the answer is no. There is no fundamental right to education because if there would presumably be fundamental rights to other things which there are not fundamental rights to. Also, the Constitution protects negative rights. The Constitution is a set of negative liberties. It is government, you may not do stuff. It is not government, you must do stuff. The government has to do very, very little. The government is required to not do a whole bunch of stuff. The government is a series of negative liberties. The government's role is to protect your right to freedom. So their interest is in protecting you and not interfering with your life. That's government's role. And so the Supreme Court points out, hey, there's no real positive rights. The Constitution doesn't really do positive rights. If Texas wants to have an education system, that's cool with us. That's a positive thing and, seems like a good idea. But it's up to Texas to figure this out. These are all legitimate and maybe some reforms are necessary, but talk to the elected people. We are not elected kings. We are here for very limited purposes. If we did stuff, we'd be acting as a super legislature. That is not what we do. So yeah, there are no legal issues here in play. So that is the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.